A New York City slip and fall case can be worth $1 million. It can be worth way more than that. The number one thing that we look for when we handle a slip and fall case is to be able to prove liability. Proving liability usually centers around the issue of notice. The person who is injured has to prove that the defendant knew or should have known about the defect, the puddle, the raised sidewalk, or the other defect that caused them to fall. Common injuries in slip and fall cases include broken bones, such as a fractured leg, a fractured elbow. A case that we're working on right now has a very serious injury. It had a total knee replacement, and it included open reduction internal fixation prior to the total knee replacement. So it was a very serious injury, and it could be a multi-million-dollar case. Slip and fall cases in New York happen in a variety of locations. For example, oftentimes people fall inside of apartment buildings. People fall on sidewalks with a raised sidewalk or hole, or sometimes at construction sites or where work is being done, debris is left, such as rocks or other tripping hazards. So the two things to really look for in a slip and fall case are, number one, being able to prove liability, and number two, developing the damages and making sure that the client sees the right doctors and also the right experts. Oftentimes in a slip and fall case, we hire a safety expert, such as an engineer, to tell us what are the building code violations or what is the safety rule that was violated. And the engineer, as an expert, will come to court and testify before a jury, because sometimes the slip and fall defect is not apparent, where everyone can just understand what it is, and an expert testimony is needed to explain a liability and to help us get more money for our client. One slip and fall case we handled actually came from a client who was rejected by another lawyer. He fell on a puddle in a supermarket, and he hired one law firm, and the law firm told him, despite the fact that he had a torn meniscus that required surgery, which is a major injury, the law firm told him, you know, I don't think you're going to be able to prove notice because you just fell on this puddle, and who knew about it? Nobody knew about this puddle. Nobody complained about this puddle, so you're not going to be able to prove notice. And they rejected the case. We looked at the case, we met with him, we met with his family members, we met with his friends, including people who were there at the supermarket, and we really spent some time having a detailed conversation with the individual. And we found out that prior to falling in the puddle, he was in the store for a period of time, and members of his family, members of his people that were with him, had also noticed that puddle, and the puddle actually came from one of the aisles. I believe it was like a bottle of detergent that tipped over. So we had a few different theories. Now we could argue constructive notice, that the puddle existed for a period of time, and in that time the store employees should have found it and they should have cleaned it up. And furthermore, we argued caused and created, because it was their own bottle that tipped over, so it wasn't properly stacked. And in a way, by improperly stacking it, the argument was that the store, the supermarket, caused and created the defective condition, which was the spill of their product onto the floor. And using that, we went to a mediation, and we ended up settling that case, which was rejected by another lawyer. The lawyer said, your case is worth nothing. I'm not taking it. We settled that case for $175,000. Even if your slip and fall accident case is very strong and the case may be worth $1 million, remember, the insurance company is not just going to write you a check. You need the right lawyer to file the lawsuit, to do a thorough investigation, to hire the safety engineering expert to go out, to take measurements, photographs, to find out what are the building code violations, what are other violations, and to really dig deep and do a great job on the case. Then the insurance company is put in a corner where they have to pay you because they have no other option. See, that's why you can't just handle a slip and fall case on your own, or have an attorney who's just picking up the phone to try to get a settlement. You really need somebody who's not afraid to go to the court, not afraid to go to trial, to get you the absolute maximum that you can receive for your slip and fall case.